Today's subject is subsidy control. Where are we now? Today's speakers are me. I'm Charles Livingstone. I'm a partner in the Government Risk and Compliance team at Brodie's. And I'm joined today by Jamie Dunne, who is a senior associate in that team. And we each have been doing quite a lot of subsidy control work since the Act came into force. So on the next slide, we have our breakdown of what we're going to cover. So I will speak a bit about the context and the legislative landscape, and I'll then say a little bit about subsidies. And I should say that we are assuming that we have a mix of people in today's audience, some of whom are more familiar than others about what is a subsidy and those sorts of questions. So for the benefit of those who are relatively new to the subject, we are going to give a bit of a recap on some of those rules. I'll then hand over to Jamie to talk about the much more interesting bits, including prohibited subsidies, ways that subsidies can be given, the subsidy control principles, the procedural and transparency requirements, and some key lessons that we have learned or that are just generally abroad since the Subsidy Control Act came into force. The background, state aid law no longer applies to the UK, ceased to apply at the point of Brexit at the end of 2020. That means that there are no more proactive approval requirements. There is no equivalent of the Commission that must sign off on state aid or on subsidies before they are lawful, and therefore no standstill requirements, no requirement to hold off giving state aid until you have that approval. The interim measure was the Trade and Cooperation Agreement between the EU and the UK, or the TCA, which does have provisions in relation to subsidies and uses very similar concepts to state aid, although uses different terminology. So it includes a definition of subsidy. It sets out principles about the awarding of subsidies, and it sets out a de minimis threshold that's equivalent to about £340,000, which is an increase from the EU state aid threshold of 200,000 that applied pre-Brexit, and that's still a rolling amount over a 3-year period. We then move past that interim stage to the Subsidy Control Act 2022, and that is a much more detailed regime than the TCA. It is, of course, a domestic regime. It's been enforced since January the 4th of last year. And it's you can think of it as the TCA plus. So there is some gold plating in there, in particular, as you'll see as we move on, in relation to the need or the breadth of application that a subsidy needs to have, the breadth of effects it needs to have in order to be caught. The TCA was focused on the distortion of trade between the EU on the one hand and the UK on the other, whereas Subsidy Control Act has a much more local focus. And it provides various possible routes for providing grants. Minimal financial assistance is the new term for de minimis, and that threshold is 315,000 over a 3-year period, so a little bit below the TCA, but still well above what the state aid rules were. So on the next slide, you can see the legislative landscape. So we have the Act itself. There are then various pieces of secondary legislation under it, including in relation to subsidies and schemes of interest or particular interest, which Jamie will come back to. Gross cash amount, gross cash equivalent regulations that help you calculate what the subsidy amount is in, for example, a below market rate loan. There are regulations about the information that needs to go in the subsidy database and the regulations about information gathering powers, etc. There's also guidance. I'll come on to the statutory guidance shortly. There's also and there's a template about how to do the principles assessment. There are streamlined routes available for some things. Again, Jamie will talk about that a little bit later on. So moving on to the statutory guidance. This is published by the Department of Business and Trade, which was BEIS, and prior to that was all sorts of other initialisms. um, about the practical application of the rules in respect of various things, including whether there's a subsidy, and that includes the CMO rules, so that's commercial market operator, which we'll come on to shortly. It goes into quite a lot of detail about the principles and how to apply them, the requirements of the Act, the exemptions under the Act, the rules on subsidies and schemes of interest, etc., and the general prohibition on the misuse of subsidies. So it's a very useful resource. And in addition to being a resource, it does actually have some legal consequence for public authorities, as they have to have regard to the guidance when giving a subsidy or making a scheme. So just as a sort of audit trail matter, it's quite useful if a public authority can kind of join the dots between what it's doing and what the guidance says, just so that you have that record of having had regard to the guidance. Make sure that you're working from the most up-to-date guidance, obviously, updated in December 2023, and it's the sort of thing that will be updated on a relatively frequent basis. So just keep checking in to make sure you've got the up-to-date one. So moving on, we'll talk about how you actually establish a subsidy. I'll cover that, and Jamie will then come back in to answer the subsequent steps in the process you should be following if you're a public authority giving a subsidy, which includes: is it prohibited? What lawful route can you use to give it, and does it satisfy the principles? So, starting with, is it a subsidy? There are 4 conditions in relation to that, which you can see on the slide. So, subsidy means financial assistance that is given directly or indirectly from public resources by a public authority, by various means. Can be a grant, a loan, a guarantee, can be foregoing revenue that's otherwise due, or it can be providing or purchasing goods or services. So essentially undercharging for something you provide, or overpaying for something you purchase. Has to confer an economic advantage on one or more enterprises. I should say all these color-coded points we'll be unpacking in the next few slides. It needs to be specific in the sense that it benefits one or more enterprises over one or more other enterprises in relation to the production of goods or provision of services. And it has to have or be capable of having an effect on competition or investment within the UK. So this connects back to that point I made about why it catches many more things than the TCA requires, or trade or investment between the UK and another country or territory. So we'll move on to the first of those, which is the public resources by a public authority, or public resources from a public authority. So taking a step back to the TCA, that refers to resources of the parties, which is kind of equivalent to the state aid test of aid granted by a member state or through state resources. Section 6 of the Subsidy Control Act defines a public authority as a person who exercises functions of a public nature. So that is quite broad and will capture bodies that don't necessarily qualify as public authorities for all purposes. But it doesn't include the legislatures. There are specific rules about subsidies given by way of devolved primary legislation. UK Parliament legislation is generally exempt from the rules. Those specific rules are a whole webinar by themselves, so we won't be covering any of that. Public resources include public funds administered by, obviously, the UK government, but then also the devolved governments, also local authorities. Basically, any kind of emanation of the state is very likely to be caught. And the funds can be given directly or through other public bodies or through private bodies. So there are lots of different routes to doing that. One query or one issue that I think is potentially needing to be resolved is the extent to which to have a subsidy, you need to have very, very concrete, the very concrete application of public resources. So under the state aid rules, that could be quite woolly, and you could get into a state aid situation even when it would be quite hard to identify on a balance sheet what the actual transfer of resources was. There's also the question of things being issued indirectly. So one well-known case under the state aid regime was Mediaset, which was about Italian set-top boxes for the switch from analog to digital TV, where the Italian state essentially gave grants to consumers, but only if they purchased certain types of box and not other types of box, and that was found to be state aid to the those who made the boxes that were eligible for the support. So a lot of these questions, and you'll get this theme as we go along, there are a lot of questions in the subsidy control regime that remain to be answered. But as a general principle, what counts is the decision to give the assistance. So if effectively a public authority can decide that a private body or some third party must give certain resources to another to a recipient, then you're probably going to have you're probably going to be answering yes to this first question, whether you have public resources by a public authority. Moving on to the next stage, economic advantage. So it's fairly obvious equivalent to the state aid advantage test. Section 3.2 requires that financial assistance is provided or has to be provided on favourable terms, and that means that the benefit to the enterprise that's receiving it is on terms that are more favourable to it than the terms that it could reasonably have been expected to have obtained on the market. So what we have there is, as I mentioned before, the commercial market operator or CMO test, which is just a new name for what you might have known as the market economy operator principle, or sometimes the market economy investor principle. It's different words because of reasons, but it's really not a different test. Some things to keep in mind in relation to this: you do need to make sure that you have appropriate evidence to back up a conclusion that you're giving a subsidy on commercial market operator terms, and you need to be able to establish that prior to actually doing it. You can't do it retrospectively. It'll be too late by that point. So you need to be looking at things like benchmarking against market offers or independent valuations. If there really is no equivalent to what you're doing in the market, then getting qualified consultants to advise on what an appropriate rate of return would be for a loan or a guarantee, for example, can get you over that line. When you're looking for an advantage, it's about whether the recipient has received a benefit, not necessarily whether the public body has incurred a cost. And I mentioned before the cash equivalent regulations, so they provide some guidance on calculating what the subsidy is when you have, let's say, a loan that's below market terms. The subsidy amount is basically the delta between that below market loan and what the recipient would have had to pay to get that loan on the market. And there's a case in relation to the provision of loans that's currently before the Competition Appeal Tribunal, which is Weiss against Greater Manchester Combined Authority. So that will hopefully produce some useful clarity on how you deal with those sorts of things. Our last bullet there is about the provision of infrastructure, because that's always a challenge. If anybody has any questions about that, feel free to put them in the Q&A. But essentially, if the state is providing something that really only advantages a particular undertaking, so a road going to your factory is really going to be a subsidy to you, whereas a road that just happens to go past your factory but also goes past lots of other people's factories and houses and schools and all that sort of thing is much less likely to confer an economic advantage on you. Our next slide is about the concept of an enterprise. So what you're looking at there, and the state aid term was undertaking. Same principle broadly. So you have to have a person or group of persons who are under common ownership or common control. And whether it's a person or a group should be engaged in an economic activity that entails offering goods or services on a market. And then the subsidy applies if the subsidy is given to that person or group to the extent that they are engaged in that activity. But this is probably the area where we've had the most development from case law. So you may have heard of the Durham Company versus Durham County Council CAT decision. That found that the enterprise that's receiving the subsidy must be separate from the public authority that is giving the subsidy. So you won't have a subsidy if the same public authority essentially just transfers funds from one internal set of accounts to another internal set of accounts, and that is a change from state aid, because state aid was very clear that an authority could subsidise itself. So if it had an arm that operated on a market, then the provision of subsidies to that arm, which advantaged it over its market competitors, could be state aid. That's not the case under the Subsidy Control Act. That rule will still apply to a public authority giving funds to another public authority or giving funds to an arm's length body, even if it's an arm's length body that it controls. I think that, that's not been decided yet, but I think that's the logic of the CAT's reasoning. So it is really only that quite narrow internal subsidy point, but that is a marked change from the state aid position. Another potentially very significant change from the state aid position is that an activity, and this is a quote of Section 7.2 of the Act, an activity will not be regarded as an economic activity if or to the extent that it is carried out for a purpose that is not economic. So even if you are offering goods or services on a market, if you are doing that for a purpose that is not economic, then you won't be participating in economic activity. So if you're a public authority doing those things and you're getting funds, let's say your local government getting central government funds, if you're offering goods or services on a market, the starting point would be that is potentially a subsidy to you with that market hat on. But Section 7.2 means that if you also need to look at the purpose, and if the purpose of what you're doing is not economic, then there isn't economic activity, and so you potentially escape the subsidy test that way. Now, that is a real departure from state aid, because under state aid, really all that mattered was that goods or services were being offered on a market, and the reason for that was irrelevant. But you can have local authorities, offering. The example we always gave in state aid is local authorities offering gyms in competition with private gym providers. In state aid, that's an undertaking. There's no doubt about that. But if the local authority isn't doing that for economic purposes, it's doing it for purposes of the health and well-being of its population, then potentially 7.2 is an out there. Similarly with things like the operation of harbours, that can be done on a commercial basis. It is done on a commercial basis. But if it's done by a public authority for the purposes purely of lifeline services, for example, then that is potentially not economic. So I think there's a lot of room potentially in Section 7.2 for public authorities that I don't think has really been tested, and that's probably an area where we may see further court decisions, and in the absence of court decisions, it may be something that authorities can rely on. The last couple of bullets there are fairly technical, so won't spend any time on those just now. Our next slide is about the requirement that assistance is specific. So that's equivalent to being selective in the state aid regime. It's not specific if a distinction in the treatment of enterprises is justified by principles inherent to the design of the arrangements. So you can see there the example given in relation to tax cases. And there are particular provisions about financial assistance given in the form of tax measures. But generally speaking, the specificity requirement means that the assistance is only available to particular enterprises and is not generally available. If something is generally available to anybody who wants it, then even though only some participants take it and therefore they're the ones who get an advantage, if the assistance itself wasn't set up to be limited to particular enterprises, then you will escape a subsidy conclusion. And then lastly, the last condition is the effect on competition or investment in the UK or on trade or investment between the UK and another country or territory. I've already mentioned what the TCA says about that. The notable thing in the Act is that the subsidy has to have or be capable of having an effect on competition or investment within the UK or an effect on international trade or investment. So it has to be capable of producing a relevant effect, meaning that it's capable of having a genuine adverse effect that's more than incidental or hypothetical on intra-UK competition or investment. So under state aid, the requirement was that the aid had to affect trade between member states. For a long time, that was a bit of a dead letter because the courts basically said, kind of assumed that all aid was capable of doing that. The Commission had started to back off from that conclusion a little bit, to the extent that now I think probably the state aid rules are a bit more permissive on this question than the Subsidy Control Act is. But it does mean that essentially, if you've already answered yes to all the other questions, you're going to have a hard time saying that there's nevertheless no effect on competition or investment within the UK, because you've already conferred an economic advantage on somebody who participates in a market that's specific to them. So saying that there's nevertheless no effect on competition, you'd basically have to be, given a subsidy to a local bakery in the Highlands that had no other bakery for 100 miles around, to have no effect on competition. So that's a quick run through the rules on what is a subsidy. I'll now hand over to Jamie to do the more interesting bits.
Thanks, Charles. Yeah, if you think back just to that four steps that we had a moment ago, where we now are, end of step one, you've established that your measure or the measure, whether it's a grant or a loan or purchasing something or providing something, is a subsidy, passing the tests that Charles has mentioned. So the first question you then have to ask yourself, if you're or the public body involved in giving a subsidy has to ask itself, is this subsidy prohibited? And there are broadly five categories of prohibited subsidy. Won't spend too much time on them, but unlimited guarantees just simply can't be given. Subsidies cannot be made contingent on export performance, i.e., we will provide you with a grant on the condition that you export at least a certain volume or a certain value in the period supported by the grant to somewhere outside the UK. Anything that's contingent on the use of domestic over imported goods or services. So you can't give a grant under a condition to buy British for the inputs that are going to be used for whatever activity the grant is supporting. A grant can't or a subsidy can't be conditional on an enterprise relocating all or part of its existing economic activity. So a subsidy cannot be given to support the creation of a factory, for example, if that is being done on the condition that the person who will be occupying that factory will move their existing production lines from somewhere else to this new factory. And the idea there obviously is just to stop subsidies being offered by different parts of the UK in competition with each other to move existing economic activity around. Although there are some circumstances in which that is permitted. So that's not a pure ban. It's in principle, prohibition, and then there are certain circumstances in which you can do that. And then finally, rescuing an ailing or insolvent enterprise, and there's all sorts of fun definitions around what constitutes an ailing or insolvent enterprise, unless certain conditions are met. So subsidies to ailing or insolvent enterprises are not prohibited per se, but they are made conditional on certain circumstances. In particular, things like restructuring plans and public interest objectives. You can't bail out a business just to bail it out, but you can bail it out if there are justifications for doing so. So if our subsidy, we've got one and it's not prohibited, then the next step is identifying a lawful route to give that subsidy. And there are, broadly speaking, four of these. One, Charles has already mentioned, the minimal financial assistance, the ability to give a small amount of money to any enterprise over a rolling 3-year period. But the others are, first of all, schemes. A subsidy scheme can be made by any public body to cover its own subsidies. And what this is essentially a framework. You create a subsidy scheme and then you can give subsidies under that scheme, a bit like a framework in public public procurement. Unlike a framework in public procurement, you can only create one that you can use yourself. A council cannot create a subsidy scheme for use by other councils, for example. The exception to that is devolved governments can make schemes for use by anybody within their devolved area. The key point about a subsidy scheme is that if the scheme itself is not challenged within the time period for a challenge under the Act, then subsidies given under it are basically exempt from the vast majority of requirements and indeed grounds of challenge under the Act, provided that they are correctly within the scope of the scheme. And there are some transparency rules around using schemes, but not the full gamut of them. Other than schemes, if we go on to the next slide, we've got streamlined routes, which are essentially UK-wide subsidy schemes, a bit like the old general block exemption regulation under state aid law, pre-approved ways of giving subsidies, if you like, that the UK government has made. There are 3 of these. There have been 3 since the Act came in. There have been no additional ones, nor any additional ones proposed. And those are for research and development, energy usage, which also covers various things like renewable heat, and local growth, which is really the levelling up one. They are quite technical, quite narrow in scope, a lot of conditions associated with them. Most public authorities have not found them particularly useful, and so they've not been particularly well used since they came in. And then there are legacy subsidies, which is to say, if you set up a scheme for giving subsidies before the Act came into effect, then you can continue running that really indefinitely, as long as doing so complies with the terms that you had set before the Subsidy Control Act came into effect. And really what that does is it grandfathers in anything that predated the Subsidy Control Act, and you can continue complying with those rules. Now, there are some permitted modifications to allow those to keep going, but by and large, they will all wither out over time. So those are becoming less and less useful to most public authorities. What you are most likely to do then, if we move on to the next slide, is decide to give your subsidy, if you're a public body, if you decide to give your subsidy as a standalone subsidy. And if you do that, then what you are required to do is satisfy yourself that it is consistent with the 7 subsidy control principles to give that subsidy. Those are derived from the TCA that Charles mentioned earlier, and they are set out in the Act. This is a self-assessment obligation. It is for the public body providing a subsidy to be satisfied, acting rationally, of course, but be satisfied that the subsidy is consistent with those principles. Those are the 7 main ones. If a subsidy relates to energy or the environment, let's say a subsidy that is to decarbonize a factory, or make a heat network more energy efficient or something like that, those will have to go through the 7 primary principles and then also a group of energy and environmental principles, but I'm not going to go into those today. So what are the principles that a decision maker has to make sure they're happy their subsidy is consistent with? Well, first of all, it has to pursue a specific public policy objective in the common interest in order to remedy an identified market failure, or address an equity rationale. And I'm going to come back to that in a little bit more detail in terms of the lessons that we've seen in the last couple of years. It has to be proportionate to that specific policy objective and limited to what is necessary to achieve it. So having identified the market failure or equity rationale and how the proposed subsidy is going to fix that, the size of the subsidy, whether in terms of its value or how long it goes on for, has to be proportionate to that objective. The third principle is that it has to pursue a change in economic behavior of the beneficiary. So if the beneficiary is going to do the same thing either way, and all that's happening is extra money is being put in their pockets, then that will not be satisfied. Costs that would not have been funded anyway is obviously very similar to that. Beneficiaries should not be given a subsidy to compensate it for something it would fund itself if it didn't get the subsidy. The subsidy has to be the least distortive means of achieving the policy objective. So if there is a a less distortive way of achieving a public policy objective, then the public body is expected to pursue that. An example of that might be where a public body proposes to spend a bit of money buying property at above its market rate in order to demolish and regenerate a given area. That's all very well and good, but you might find in some circumstances that there would be a less distortive way of doing that by, for example, doing a compulsory purchase of those properties rather than paying over market rate for them, and where that would be an appropriate way of achieving the final aim of the subsidy, that should be pursued instead. Subsidies should be designed to achieve their policy objective while minimising negative effects on competition or investment within the UK. Now, that's not the same thing as not having distortive effects on competition. If the subsidy isn't going to have distortive effects potentially or actually on competition, then it's not a subsidy. But if it is going to have those effects and it is a subsidy, then the thing has to be designed to minimize what those distortive effects are through, for example, conditions on what the recipient can do with the money. And a lot of these principles require the careful design of grant or loan or whatever it is, agreements, and the imposition of certain terms on the recipient. And then finally, the overall benefit, the benefit has to outweigh the cost. The subsidy has to achieve something that outweighs the harm to the free market, essentially. So if you're happy, if the public body's happy that those principles are all satisfied, the next question is it dealing with a subsidy of interest or particular interest? And that's dealt with on the next slide. Essentially, subsidies of particular interest are particularly high value or potentially distortive subsidies. Subsidies of interest are still more high value or distortive than others, but not quite so much as those that are of particular interest. What's the difference? A subsidy of particular interest, as defined in this slide, has to be referred to the Subsidy Advice Unit within the Competition and Markets Authority before it is given or made, whereas a subsidy of interest can be voluntarily but does not have to be. All I'll say on that is that as far as we are aware, and as far as others practicing in this area are aware, the CMA is still not in the habit of accepting any referrals for voluntary subsidies because it's far too busy to do so. But subsidies of particular interest, do keep an eye out for if you're going to trigger that, because you have to build that into the timescale that you're allowing between a decision to give a subsidy at the end of your assessment of the principles and actually putting that money out the door. Moving on then to the practicalities of that, referrals to the CMA's Subsidy Advice Unit, they have to be made through a public authority portal that's set up for that purpose. The Subsidy Advice Unit then gets 5 working days to decide whether to report, or if it's a voluntary referral, or whether the referral contains all the information it needs to report in the case of a mandatory one. If it accepts it, then it will announce that on its website, and then it will publish the report at the end of a 30 working day period, capped at 30 working days, but it pretty much always is 30 working days, at the end of the 30 working day period, saying what it thinks are the flaws or the strengths of the assessment against those principles that the public body has undertaken. This is an advisory report, it's there to help, but of course, the more holes the CMA picks in a given principles assessment, the more potential challenges that subsidy might face from somebody who says that actually that it's not been done properly, it's not complied with those principles. There is a 5 working day cooling off period, although that might be extended by the Secretary of State if there are serious problems. The key point really there again is to, if you have identified a subsidy that is a subsidy of particular interest, be very careful that you have built this into your time frame, because we have seen public authorities come up against that before. Moving on then to some of the transparency rules. One of the key things about the new regime, and I won't spend long on this, is that there are a lot more requirements in terms of details that have to be published on a UK government database. Those details are set out in regulations, but effectively all of that information has to be uploaded to that online database and anybody can view it. And we've included the links and indeed the contact for registering there for those that would find it useful. Um, Moving on, because I don't want to hover on that, the more interesting things are some key features of the new regime then. Um, Subsidies of particular interest, I've noted. You've got your voluntary setup, you've got your mandatory ones, and be careful about that. Having received a report following a referral, the question then is whether to proceed with it. Um, do you want to go back and revisit the subsidy principles assessment, or are you content with the situation you've ended up in? Do you want to change the terms of a grant or a loan or whatever it is, or are you happy with where you are? Um, if somebody wants to bring a challenge, somebody who risks suffering loss as a result, typically a competitor of the recipient of a subsidy, albeit not necessarily restricted to that, the rule is in the legislation is a person with interest, then a challenge can be brought in court basically as a judicial review, essentially saying that the public body hasn't acted lawfully, or it hasn't considered everything relevant, or it's acted irrationally, so on. The level of detail to go into the transparency database can be quite extensive, albeit ought to be proportionate to what is being done. If you are giving assistance as minimal financial assistance, there are certain hoops that you have to jump through. You can't just stick £100,000 in somebody's pocket and not worry about it. You have to take declarations from them about what they've had from the rest of the public sector, and indeed what their corporate group has had from the rest of the public sector in a 3-year period, and put them under an obligation to maintain a record of that. And the statutory guidance has some handy language on this. And then, as Charles says, if you are looking to apply the commercial market operator rule, that is to say, this isn't a subsidy because it's something that any private funder would do, or buyer, or whatever else, then you really need to be careful you've got the evidence base to support that. So some of the highlights or sort of particular features on the next slide then of the new regime, we've mentioned there's no longer a presumption against subsidies. It's not the case that subsidies are banned unless you can identify exemption in the GBER, for example, but there are specific prohibitions. Beyond that, it's about being happy that it's consistent with the principles and that you've done the legwork to support that conclusion. The commercial market operator rule will see more detail coming out of the Weiss case that Charles mentioned around what are commercial terms for loans, for example, and what sort of evidence you need in order to reach that conclusion lawfully. Purely local subsidies are now covered in a way that arguably they weren't before. Charles has mentioned that. I won't hover on it. Charles also mentioned internal subsidies. That is a key point here around no longer being restricted from moving funding from one part of a public body to another, albeit we'll see how that applies in sort of slightly more nuanced circumstances. I think one of the key points that I did want to hover on for a minute was this one about market failure or equity rationale. A lot of the time we see people focusing on trying to identify a market failure where not necessarily there isn't necessarily one actually there, and looking and actually you'd be better off looking at an equity rationale for a subsidy, a benefit to the public perhaps in an area that has fewer jobs or lower life expectancy, or something that can be remedied in that equity sense by investing more money in an area. Subsidy schemes can be superficially attractive in terms of not having to jump through the hoops for every single subsidy. If you satisfy yourself that the scheme is consistent with the principles, then you don't have to apply that assessment to individual subsidies under it. However, it is a much harder thing to do because you have to, when assessing the scheme, satisfy yourself that all potential subsidies are going to be consistent, which is obviously difficult. Streamlined routes I've mentioned have not been particularly useful. The next slide notes there have, at the time of writing, been 37 referrals to the Subsidy Advice Unit. Really, what I'll do is I'll let you see those slides, but we'll move on to that slide and those bullets. But they're really covered in the next slide, and that's really my final one, which I will hover on for a minute, um, which is really the lessons so far coming out of the regime. And I've grouped these into four. The first one is identifying a subsidy. Um, Look for purely local subsidies, look for potentially distortive effects on competition. Do not try and pretend they don't exist by looking at how you're going to minimize them. That comes later. The starting point is whether there is any potentially distortive effect, and accept a subsidy for what it is. Market failure versus social equity rationales. Don't try and pretend there's a market failure where there isn't one. Sometimes the market delivers bad effects. Sometimes those have social issues, but that does not mean it's a market failure. The market has not failed because house prices are high. The market has failed if house prices are high and people are still not incentivized to build houses that are environmentally friendly. Distortive effects, don't try and pretend they're not there. Face them head on and then figure out how the subsidy can be designed to minimize them, but don't worry about making them go away. Subsidies will often have distortive effects. The key point is keeping them as low as they can be while still achieving the objective. There's no point in minimizing distortive effects so much that you don't actually achieve the thing you set out to achieve, and you're not expected to do that. And then finally, on evidence base and justification, please don't rely on external objectives. The number of these assessments that often refer to Scottish government objectives or UK government objectives or so on, that's not going to cut it. You need to identify what your objectives are specifically for the subsidy and then go from there. And the CMA has been quite critical about some of those. It's not a box ticking exercise. You've got to put the time and effort into considering what your subsidy is and the effects of it. And in particular, where it's proportionate and appropriate to do so, consider taking some economic advice on the potential impact and the potential benefits. So that's left some time for questions, Charles.
Yeah, thanks, Jamie. So we've got a couple. Sorry, apologies, folks. I've been turning my camera on and off. I've got a cold, and I thought I'd spare you the sight of me coughing and sneezing. So first question, is subsidy involved when a public authority administers private funds? For example, a private company hands over funds to a public authority for a community grant scheme. Jamie, what do you think?
It depends effectively on who decides who gets it. If it's purely administrative, so if, for example, a private body sets the terms of who receives its money, and the public body simply administers that, then you might well not give rise to a subsidy. But if, on the other hand, private money rather goes into a public pot, and then the public decision maker decides who gets it, it effectively becomes public money in public hands.
Yeah. Question about slides. You will get the slides as well as a link to the recording. So question, do you anticipate the MFA, minimal financial assistance threshold, being increased periodically, or is the current threshold likely to remain unchanged? Guess it depends how aggressive inflation is, and what you mean by periodically. So yes, from time to time, but not on a sort of annual basis. I wouldn't have thought. If you think about how long the EU de minimis threshold was untouched. There's probably a degree to which certainty is actually quite a good thing, particularly when it's calculated over a rolling 3-year period. If you're changing that all the time, that just becomes a nightmare to work out. The question, can we proceed with a subsidy if we suspect the recipient will relocate even if they're not required to do so? Jamie?
Yeah, so the rule is that you can't make subsidies conditional on relocation. And it doesn't matter when the relocation happens, by the way. Making it a condition to move before you get paid is no better or worse than making it a condition to move within 5 years of getting paid. But provided it's not a condition, you don't have to prevent or ban the recipient from moving their factory. You just can't be responsible for that decision yourself.
Yeah. And then a question about whether the subsidy control database is universally used. Um, it's probably more of a question for the public authorities who are in the audience, but if you've ever looked at the subsidy database, so if searching for standalone subsidy awards, there are only 1,129 shown on the database. If you think there have been 37 that have been referred to the CMA, and the fact that the database includes some that were recorded under the TCA before the Act even came into force, there is absolutely no way that that is all the subsidies that have been granted under the Act. So I think there is widespread non-use of the database. That has its own issues in the sense that authorities have a duty to use the database, so there's a failure to do that. The main reason to use the database, though, is that it provides you with protection from challenges because it starts the clock running. It's not unlike a contract award notice in procurement. At that point, the clock is running on somebody's ability to challenge. So if a subsidy is never publicised in the database, then that clock never even starts to run, and somebody could challenge that basically at any point. It remains a sort of a permanent risk. So if you're in a public authority and you're not using the subsidy control database, then you may want to consider making that more of a practice. And the other thing I'd say about it is, at least in terms of what's apparent on the face, I don't know if you can drill down into it more than I have, but the authority is not actually named in the database. So it's not like, unless it's the recipient of like central government funds. So it's not like if you have known troublemakers that they can just go on the database and look at all the subsidies you've awarded and then start submitting FOI after FOI about it. It's actually the recipient that's named. So I'm not actually sure how useful the database is to anybody who would be concerned. They'd really need to know about a subsidy in order to then know what they're going to look for on the database. So as transparency goes, I think the database is actually pretty rubbish. But the important thing from a public authority perspective is that have that rubbish entry on there that nobody will pay any attention to. And then when news of the subsidy breaks in 6 months or a year, you can say, well, it was publicised, so nobody can do anything about it now. Jamie, anything to add on that point?
No, I think that's exactly right. And well, I suppose the other thing that you don't get on the subsidy database is things that people have concluded are not subsidies. But of
Yeah.
course, that does not stop you getting sued because Greater Manchester Combined Authority didn't think it had a subsidy in Mr. Weiss's case, and Mr. Weiss disagreed.
Yeah, that's probably the main risk category, actually. Things that might be a subsidy, but you proceed as if they're not.
Yeah.
Sometimes you're better just doing the principles assessment. Although on other occasions, you save yourself a lot of time if you can get to a robust no subsidy conclusion. So swings and roundabouts, I suppose. Okay, we're just going to wrap up. On the next slide, got details, conscious that this audience might be quite interested in procurement as well as subsidy control. We're doing a webinar on the new Procurement Act next week. It is focused on contractors and suppliers. But you might nevertheless want to come along and hear what your counterparties are being told. We did one for public authorities last month, and we'll maybe include a link back to that in the email follow-up that you'll get in relation to this webinar. The next slide has our contact details, so when you get the slides, you'll have those. The last thing I'll say is that when you leave the webinar, you should get a very short survey. If you can fill that out, that information is really useful to us, so it'd really be appreciated. Otherwise, it's just for me to say thanks to Jamie and say thanks to all of you for attending, and we hope to see you next time. Bye.